Welcome to the Deep Dive. We're here to unpack complex legal issues, give you the core insights, and, well, cut through some of the jargon.
And today, we're really diving deep into Florida constitutional law, specifically a statute that honestly causes a lot of heartache.
Yeah, we're talking about Section 768.21, subsection 8. It's part of the Wrongful Death Act.
Right. And it stops certain people think adult children whose parents weren't married from getting non-economic damages in med-mal wrongful death cases, stuff like pain and suffering.
It feels incredibly harsh, and maybe unsurprisingly, people are always trying to challenge it in court.
Absolutely. And there's this one case, Kluger v. White from 1973, that always seems to come up. It gets treated like this magic key.
The silver bullet, yeah. The idea that Kluger is the way to get the courts to strike down this damages bar.
And that's the myth we really need to tackle today, because unfortunately, it's just not that simple. The Florida Supreme Court has drawn some pretty clear lines.
So our mission today is to understand those lines. The difference between, say, denying someone access to the courthouse altogether,
Which is what Kluger was about.
versus the legislature defining the scope or the limits of a right that it created in the first place, like this wrongful death statute.
Exactly. If you can really get your head around that distinction, you'll see why challenging this specific damages bar using Kluger is, well, basically a settled issue legally.
Okay, so let's trace that framework. We need to look at Kluger, then a case called Smith, and finally, the big one for this issue, Mizrahi.
Right, let's start with Kluger. It's the bedrock. It's all about Article 1, Section 21 of the Florida Constitution, the Access to Courts Clause.
Which sounds really straightforward.
Yeah.
The courts shall be open to every person for redress of any injury.
Sounds broad, right? Like, if you're injured, you get to sue, period.
But Kluger had to define what that actually means when the legislature wants to completely get rid of a legal claim, a cause of action.
Okay, so what's the test? How hard did Kluger make it for the legislature?
It set up two very high hurdles. If the legislature wants to abolish a right that existed under common law, you know, the old judge-made law. Right, the stuff that predates statutes.
Exactly. If they want to get rid of one of those rights, they have to do one of two things. You could call them the trade-off test or the sky's falling test.
Okay, break those down. Trade-off test.
Simple idea. If you take away my right to sue for something, you have to give me a reasonable alternative way to be made whole. Like, you take away my right to sue the driver who damaged my car.
But you make car insurance mandatory, so I get paid anyway.
Precisely. You trade the lawsuit for some other guaranteed remedy. That's the trade-off.
Makes sense. What about the sky's falling test? Sounds dramatic.
It is, because the burden is huge. If the legislature doesn't provide an alternative, they have to prove two things. First, an overpowering public necessity for abolishing the right. Like, society will collapse if we don't do this.
Okay, that's a high bar.
And second, they have to show that no alternative means exist to deal with that crisis. Wiping out the right to sue has to be the only option left. It's incredibly difficult to prove.
So, in Kluger itself, what was the right they were protecting?
It was a very specific common law right, the right to sue a negligent driver for property damage to your car. Basic stuff existed for ages.
And the legislature tried to limit it somehow.
They passed a no-fault law, but the required insurance was optional. So there was no guaranteed alternative remedy. They didn't meet the trade-off test.
And they couldn't prove the sky's falling necessity either.
Nope. So the court struck down that part of the law. Access to courts was denied without meeting the high bar.
Okay, so the key takeaway here, the absolute crucial point about Kluger,
Is that it protects pre-existing common law rights. Rights that were already on the books, so to speak, before the 1968 Florida Constitution was adopted. It's about preserving those old established ways to get redress.
it's like a historical preservation clause for old legal rights. It's not about creating new ones or guaranteeing a payout for every possible harm someone might suffer today.
Exactly. It protects the procedure, the access for those specific historical rights.
Okay, so Kluger guards the old common law fortress. But what happens when the legislature deals with rights it created? Modern rights, statutory rights.
Now we get to the heart of the matter for our statute. This brings us to Mizrahi v. North Miami Medical Center, decided in 2000.
And Mizrahi tackled our statute, section 768.218, head-on, the adult children damages bar. Did Kluger apply?
The Florida Supreme Court said a clear no. Kluger did not invalidate this statute, and their reasoning is the wall the challengers keep running into.
Why? What were the reasons Kluger didn't fit?
Three main ones, but the first is the big one. No common law origin.
Meaning?
Before Florida passed its first Wrongful Death Act back in the day, and certainly before the modern 1972 Act, if someone died because of negligence, their family couldn't sue for their own suffering or loss. The legal claim essentially died with the person.
Wow. Okay, so the right for survivors to sue is entirely,
A creature of statute, made up by the legislature, not inherited from Old English common law.
and that leads to the second point, I assume.
Directly. If the legislature created the right, if they built the house, so to speak, then they also get to define its limits. They can define who gets to sue, what kind of damages they can recover, or even abolish the right entirely if they choose.
So the argument is, they gave with one hand, they can limit or take away with the other, without offending the access to courts clause.
That's the core principle the court adopted in Mizrahi. The legislature is the architect of purely statutory rights.
Okay, but let me push back a bit here. This feels lawyerly, maybe. If someone's parent dies due to clear medical negligence, and they're told, tough luck, you get nothing for your griefs because your parents weren't married, isn't that functionally denying them access to redress for a very real injury?
That's the emotional and, frankly, moral argument. But the legal distinction the court drew is sharp. They said the survivors still have access to the court. They can still file a wrongful death lawsuit.
But for what, if non-economic damages are off the table?
They can still potentially sue for economic damages, lost financial support, medical bills incurred before death, funeral expenses, things like that. The court reasoned the legislature didn't abolish the entire cause of action.
They just severely limited who could recover a specific type of damages, the non-economic ones, which are often the largest part.
Exactly. So the court said this limitation doesn't trigger the high Kluger standard. It's seen as the legislature defining the scope of the statutory right it created. Article 1, Section 21 doesn't guarantee relief for, as the court put it, every injury imaginable.
So the mistake is conflating denial of a certain type of recovery with denial of access to the court system itself.
That's the doctrinal divide. Kluger protects the procedure for old rights. Mizrahi confirms the legislature's power to shape the substance of new statutory rights.
This is starting to make sense legally speaking, even if the outcome feels harsh. Now let's rewind a bit before Mizrahi. You mentioned Smith v. Department of Insurance from 1987. How does that fit in?
Smith is crucial because it happened during a big wave of tort reform in the mid-'80s. The legislature was really testing the limits of Kluger right after a medical malpractice insurance crisis. Smith sort of refined the Kluger rule.
How so?
It drew a really important line between the legislature abolishing a cause of action entirely.
Which triggers the tough Kluger test we talked about, trade-off or skies falling.
Right. Versus the legislature merely regulating a cause of action, putting rules and restrictions around it.
And regulation gets an easier standard of review.
Much easier, just rational basis review. The legislature basically just needs a rational reason related to a legitimate government goal, like controlling litigation costs or insurance premiums. It's a low bar.
So what happened in Smith? What did the court look at?
They looked at the 1986 Tort Reform and Insurance Act. It had a bunch of things: mandatory pre-suit investigation, limits on lawyer fees.
And the court said those were okay as regulations.
Generally, yes. They saw those as reasonable procedural restrictions, rationally related to trying to stabilize the insurance market or whatever the stated goal was. They were regulations.
But Smith is also famous for something it struck down.
Absolutely. It struck down the $450,000 cap on non-economic damages in all negligence cases.
Why? Wasn't that just a regulation, a limit?
The court said no. A cap that severe, they reasoned, wasn't just regulating the right to recover damages. It was effectively eliminating a substantial part of the recovery for the most severely injured people. It crossed the line from regulation back towards abolition.
Ah, so it bumped the standard back up.
Exactly. Because it looked like abolition in practice for some, the court demanded the legislature meet the high Kluger standard, prove that overpowering public necessity and no alternative means.
And the legislature couldn't.
They couldn't convince the court, so the damages cap was struck down under Kluger-Smith.
Okay, so Smith sets up this distinction. Regulate is easy, abolish, or severely limit damages, is hard and needs the Kluger justification. But you said Smith also paved the way for Mizrahi.
How? Because even while striking down the cap, the Smith court explicitly affirmed the legislature's broad power. It said the legislature may alter, modify, or even restrict causes of action to promote the general welfare and to respond to perceived social or economic needs.
Okay, I see. That language gives a lot of leeway to the legislature, especially when dealing with rights they created themselves.
Precisely. It reinforces the idea that the legislature has significant policy discretion. Mizrahi later picked up that thread and applied it specifically to the statutory wrongful death context, saying defining who gets non-economic damages is within that legislative power to alter, modify, or restrict.
Right, let's tie this together then. We have Kluger in 73 setting a high bar to abolish old common law rights.
Then Smith in 87 saying, okay, you can regulate more easily, but severe limits might still trigger Kluger.
And finally, Mizrahi in 2000 looking specifically at the wrongful death damages bar for adult children and saying, nope, Kluger doesn't apply here at all because this right is purely statutory. The legislature can limit it.
That's the trajectory. And the inescapable conclusion for lawyers today is that trying to use Kluger to challenge Section 768.218 is, frankly, banging your head against a wall the Florida Supreme Court already built and reinforced.
The court has spoken quite definitively on that specific argument.
Yes. Relitigating Mizrahi based on Kluger seems like a legal dead end.
Okay. But legal arguments evolve. We've heard whispers of a, let's say, more novel approach trying to get around Mizrahi, something about juries.
Ah, yes. This is where things get creative, trying to find a new angle. The argument shifts focus entirely. Instead of saying the plaintiff is being denied their right to recover damages,
Which Mizrahi said the legislature could limit.
right. The new argument frames the harm differently. It says the statute causes a systemic disenfranchisement of jurors.
A jury participation denial. How does that work? How does that sidestep Mizrahi?
The idea is that injury isn't just to the individual plaintiff, it's a structural injury to the constitutional role of the jury. By barring recovery for non-economic damages in these specific cases, the law allegedly prevents jurors from fully exercising their fact-finding and damage-assessing role in the civil justice system for a whole category of wrongful deaths.
So it's not about the plaintiff's lost compensation, but about the jury being artificially limited in its function.
That's the theory. It tries to frame it as a violation of the constitutional right to trial by jury, or maybe equal protection for jurors, rather than an access to courts issue under Kluger as applied in Mizrahi. It's a different constitutional hook.
Interesting. Definitely creative. Sounds like a tough argument to win, though.
It's certainly novel,
Yeah.
and it avoids directly contradicting Mizrahi's holding about the statutory nature of the right. Whether it would succeed is another question entirely.
So if the direct Kluger challenge is blocked by Mizrahi,
Yeah.
and this jury argument is maybe the long shot, what's the most realistic path forward for people who want to change this law? The sources seem to point away from the courts.
They do, and it brings us back to why the Mizrahi court upheld the statute in the first place. Remember, even if Kluger didn't strictly apply, the court still deferred to the legislature's reason for the law.
Which was?
The legislature, back in the late 80s, declared there was an overpowering public necessity, that medical malpractice insurance crisis we mentioned. They argued this damages bar was needed to keep doctors insured and practicing in Florida.
Okay, so the court basically accepted the legislature's crisis justification at the time?
Right. So the most pragmatic strategy now isn't to refight the legal battle decided in Mizrahi. It's to challenge the factual basis for the law today.
The change conditions argument.
Exactly. The core question becomes, does that overpowering public necessity, the supposed insurance crisis that justified this specific damages bar back in the 1980s, still exist today?
If the crisis is over, then the justification for the law disappears.
Precisely. If the original factual predicate is gone, then keeping the law on the books could be seen as arbitrary and capricious. It's no longer serving its stated public purpose, and it's causing harm without justification.
And the best way to demonstrate those changed conditions isn't a lawsuit, but
Convincing the legislature to create a new task force to study the issue.
why a task force specifically? Why not just lobby legislators directly?
A task force offers several advantages. One, it puts the issue squarely back in the legislative branch's court, which is appropriate for what is fundamentally a policy question involving balancing interests.
Makes sense. What else?
Two, it creates a formal process to gather current data. What are the insurance market conditions now? What are the real costs? Is this specific bar actually affecting premiums or defensive medicine today? You get a neutral, modern evidentiary record.
That sounds crucial. And politically useful for lawmakers.
Absolutely. It gives them political cover. They can say, we're not just reacting to pressure, we're commissioning an objective study to get the facts. It looks responsible and data-driven.
And then based on that data.
They can recalibrate, repeal the subsection, amend it, maybe replace it with something else entirely based on today's reality, not the reality of 30-plus years ago.
So it shifts the focus from this law is unconstitutional or this law is immoral to
2, is this law still necessary? Is it still doing the job it was created for based on the current facts?
Yeah,
It's an administrative responsibility argument, not just a legal or moral one.
that feels like a much more strategic approach given the legal history we've just walked through.
It respects the precedent set by Mizrahi while directly addressing the legislature's own stated justification for the law. Hashtag tag 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 outro.
Well, this has certainly been a deep dive into a complex corner of Florida law. The big takeaway seems clear. The Florida Supreme Court, through cases like Kluger, Smith, and especially Mizrahi, has effectively closed the door on using traditional access to courts arguments to overturn statutory limitations like the wrongful death damages bar in Section 768.218.
That path, arguing Kluger applies, is blocked by Mizrahi. The court has drawn a line between protecting ancient common law access and allowing the legislature to define the scope of rights it creates by statute.
So we'll leave you with this thought. When a law's justification rests on a specific historical crisis, maybe the most potent challenge isn't always found in constitutional text or legal precedent.
Maybe it's found in empirical reality. The most effective tool might be rigorous, data-driven re-examination to ask, does the crisis that birthed this law still exist today? For this specific damages bar, the next chapter likely unfolds not in the Supreme Court, but in a legislative task force committee room.